the computer. Good evening. Welcome to the webinar focusing on wills for blended families and complex families. So in terms of the complex families I'm going to be focusing on tonight are families where there are a beneficiary that is vulnerable in some way. So a disabled child or a child with some other kind of issue, managing money, drug problems, something like that. So we'll come to that later, but firstly, blended families. So we're certainly going to get through that tonight. So those of you who are watching the replay, there is still a Q&A function, so you can still access that, and it'll send me an email, and I will respond within 24 hours or so. So let's jump in. Questions at the end. Hopefully I answer a lot of the questions as we go. We will see. So my name is Jackie Broman. I own TBA Law. So I've been running that firm for a bit over 8 years, coming up to my 9th year. We're in central Victoria, in Melbourne, but subject to the pandemic, obviously, not going in for appointments. We're running most of our appointments via Zoom. The emergency legislation that was introduced during COVID allows us to do all our signing online via Zoom as well. So that's made doing estate planning a whole lot easier. And in fact, I'm getting a lot of work from New South Wales and Queensland as well as around Victoria. So hopefully some changes are worthwhile that has happened. It's made the law move a little bit quicker. Now, I'm an accredited specialist in wills and estates. So I did my master's degree specifically in wills and estates. And then after that, I did a 12-month program with the Law Institute of Victoria with a big examination process at the end and passed that. So to give you some perspective, there is about 22,000 lawyers in Victoria, and there's only about 80 of us with the wills and estates accreditation. And other than being a solicitor, there are other things in my life that I do. So there's a photo there of my fur baby, one of them, on our boat out fishing. So I love being out on the ocean. It's a chance to get right away. This dog needs to be tied up or else he'll go straight overboard. But at least he enjoys it. So that's a little bit about me. So we're focusing mainly on wills tonight, which is an element of estate planning. Estate planning, though, in 2020 is not just about wills. Maybe 50, 60, 70 years ago, all people needed was a will, but the complexity of life these days is such that we're living longer. We now have superannuation. The dream of only owning one home is probably now in the minority, where people have multiple investments, various different kinds of investments. Tax laws have changed. We have often trust structures. More people have businesses and other interests. And while we're also living longer, that means that we often don't die at home. We have all the health issues that happen with the decline of age. So that has made powers of attorney more important, someone to make your medical decisions more important. So all of those elements are part of the estate plan. And look, with a blended family, appointing people into the right roles is just as important as the will. And we will talk a little bit about executors tonight. And appointing the right executors is just as important as appointing the right power of attorney. You don't want a fight between your current spouse and your children from your former relationship. You want to make it really clear who has the power to make decisions, or else there might be some doubt about that. So, having said that, we're going to jump straight into a case study that I like to use because most people will have seen the Modern Family series. So this is actually a blog that I did a couple of years ago that I like to use as a case study. And we're focusing on that family in the middle there, which is a blended family. So Jay is the older gentleman. His second wife is Gloria. Jay has 2 adult children from his first relationship, and he's got a stepson, and then he's got a son to his second marriage as well. So there's the element of not only coming into a relationship with 2 sets of children, there is now a child in the new relationship as well. Now, the difference with this case study is that Jay's actually pretty well off. So he can meet the obligations that he needs to meet. Whereas I think a lot of the difficulties arise in blended families when there aren't as much to go around, or it hasn't been thought about early enough for provision to be made. So for this example, Jay runs a business. Let's say the business is worth about $1 million. He then owns his house and there's some money in the bank. Let's say that in total there's probably about 4 million of other assets. So he's got about a $5 million estate, and then he's got superannuation of another $1 million. So he's doing pretty well. No life insurance because he has enough, and no debt. So doesn't need life insurance to pay off any debt. So the first thing Jay is going to think about is executors. Now, who is going to be the best person to manage his estate when he passes away? Who's the best person who is going to weigh up the relationships the best and not cause problems? Who is the person who's got the time and capability? You need to consider the personalities involved when you're appointing people into the roles. So in this case, he could appoint Gloria alone. That wouldn't be a problem necessarily. What it can do in some families is isolate the children from the first marriage, and they get defensive and uncertain about what's happening. You can have up to 4 executors. So he could have both his children from his first marriage and his wife. He could have them all acting together. That wouldn't be such a bad thing. And in fact, when there are still minor children, so Manny and Joe are still under the age of 18, you do need 2 executors. You can't just have one when funds are being held for children. So I'll come back to what he decides in a minute, but those are the things that he has to think about. He could also appoint an independent person. He could appoint a friend. He could appoint a professional. Now, he also has to think about guardians for the kids. So if him and Gloria should go together in a car accident, plane accident, all sorts of situations, he's also got to think about the guardianship for both Manny and Joe. So him and Gloria don't want Manny to be going back to South America. They want to make sure that he stays in America. They want to make sure that that is a sound option. Now, in Australia, it might just be a matter of making sure the kids are stable in a certain state and aren't removed, or even a particular location. So he's also thinking about, well, who's in the right stage of life to look after kids as well. Gloria has family of a similar age to her. Jay probably doesn't want to think about his brothers and sisters, but he does have children who have children about the same age as Manny. So they are jointly making the decision that they wouldn't mind either of Jay's kids being the guardians for essentially their siblings. The other thing they have to think about, though, is what happens if one of their kids goes through a divorce. Would they want Manny or Joe to live through a divorce situation? They want to make it clear who the children end up with in a situation like that too. Now, superannuation is an asset that is not usually covered by your will. So superannuation is an asset that you can use to weigh some of these obligations between beneficiaries in your life. So you have an obligation to your spouse, you have an obligation to your children. Your obligation to your spouse actually overrides obligations to your children. The law in Victoria says that you have to make sure your spouse is housed and has a nest egg. And then anything else after that can go to kids. So if kids try and dispute a will that says that, they've got a very little chance. But superannuation then is something that you could potentially funnel directly to children, not through the will. So the children get something. No one can challenge it if you've done a binding nomination on your super fund. So Jay's also weighing this up. He's thinking, well, should I give a lump sum through to the kids up front? Should Gloria get it all? How can I manage this? Because the other thing to think about, though, is tax around superannuation. So a spouse doesn't pay tax if they get super. Children under 18 don't pay tax if they get super, but adult children do. So it's weighing up whether you've really got a tax issue there or if it's not that much of a priority for you. So overall, he's also thinking about, well, how is he going to meet the obligations that he has to everyone with the rest of his estate? So he's got a $5 million estate. The house is probably the biggest asset, and then his business after that, and then some savings and investments. Now, he doesn't really trust that Gloria is going to be able to manage all that. Gloria is also about the same age as his children, so she might live just as long as his kids. So he is also thinking about, well, how do I weigh this up? Should he treat Manny the same as his own biological children is another thing to think about. Manny's a stepchild, but he and Gloria have been together long enough that they've sort of pulled everything together anyway. So why should Manny be treated differently? So these are the things that he's weighing up. His business as well, he's thinking about in terms of business succession. So Claire, his daughter, works for him in the business. He could make some binding directions through the business itself so that Claire ends up with that directly. Won't have to go through the will that way. So people who are running a family business can sometimes have a bit of extra flexibility there, because a business doesn't necessarily become an estate asset. You can filter things through the business and make sure the business is directed through control to someone else. So there's another potential there. So what does he decide? He needs two executors. He decides that Mitchell, his son, adult son, and Gloria, his wife, are going to be the executors. So he needs two. He doesn't want to make his children feel like they're on the outer. He also wants to give his wife the credit that she's responsible. Mitchell's there to counterbalance any eccentricities of Gloria's. Mitchell's also a solicitor, so he knows how to do a lot of the stuff practically. So that's a pretty good decision. He puts Claire in there as a backup for if something happens to either Gloria or Mitchell. So there's always two. Then what he does is directs his super directly to Gloria. So he makes the decision, no, she's going to have that cash up front. That is something he wants to do for her. So she's going to get $1 million in super. There's her nest egg. She's going to be well and truly kept in the lifestyle that she's used to. And there's no tax paid on that super. Then what he does is say, I want to make sure that my kids get something up front, because again, Gloria's a similar age, so he doesn't want them to have to wait for a lifetime. So he gives a straight up legacy to all 4 of the kids of $250,000. So there goes another $1 million. So $250,000 each. For the 2 minors, it's held back until they're 25, so it goes into a minors trust. And then what he does with the balance, of the $4 million in his estate, is that he actually puts it into a trust for Gloria. So she doesn't own it outright. She has the use of the house for life. She gets to have the interest off the $4 million, but it's not hers to dip into. She's got $1 million in super, and then she's got a house to live in. She's looked after, but that is only for life. Once she passes away, that trust is then split 4 ways between the 4 kids. So he does end up thinking, well, Manny should get a quarter because, you know, Gloria doesn't have much to give him on her own, and his father certainly doesn't have much either. So why not? Then he has Claire, his daughter, as the guardian for Manny and Joe. So that's where he ends up. So you can at least see some of the elements that he has worked through. So he's weighed up a lot of obligations and issues around claims. So claims against estates, I suppose, are the thing that people are most worried about. And yes, the people you have obligations to are your spouse, your children, and stepchildren you have an obligation to as well. Adult children and stepchildren, it starts minimizing. They do have a responsibility to look after themselves to a degree, but your first obligation is to your spouse. The longer you're together, the more the obligation is. So you have to look at how you own your assets as well. So some of the things in the example we've used for Jay were quite an easy example because Jay owned all that himself. Whereas when a new couple comes together, they might then pool their assets and end up owning things jointly. So when someone owns an asset jointly, it means it automatically goes to the other person when the first person passes away. So it excludes that asset from an estate asset. So like a house, if you go in and buy a house together and you have both names on it, if one of you passes away, it automatically goes to the other. So that means that no children can dispute that the house is the surviving spouse's house. So they are secure in a house. But then what you have to think about is, well, how do I then make sure that that house ends up coming back down to my kids as well? And that's something that this couple needs to talk about up front. You know, do we agree at this point to leave everything to each other on the understanding that we will then split things evenly between all our kids? Is that the way we go? Or do we do something because, like what Jay did, because our assets are separate, and we I'll provide for you and put it all in trust, but it's on the understanding that when you pass away, it comes back to my children because it was my asset originally. So all these things are something to consider, and looking at how you own an asset is important. Again, your superannuation is something as well to use. Remember, your superannuation often includes a life insurance component, so the actual death benefit itself can be quite a sizable chunk when you take into account what you saved plus the life insurance. So do think about that. Or consider taking out separate life insurance policy, and specifically directing the life insurance policy to either your spouse and everything goes to your kids, or vice versa, if you believe there's an issue. What not to do. So don't not talk about it. It is something that you need to openly discuss with each other, explore the scenarios, get it out on the table. Yes, it can be confronting, but it shouldn't be something to be taken offense over. It's just an exploring of the options. But the other thing is that people make claims against wills when they are surprised by the outcome. So setting the expectations with the children as early as possible is really important. So making it clear, you know, this is my spouse. I'm making sure that they are taken care of first. We have this arrangement that when both of us pass away, you will be provided for. So you won't get anything up front. You need to wait, right? I think that a lot of kids, you know, in Generation X, Y, and the newest generation really need to hone their expectations, because realistically, our parents are going to probably spend everything. I think that it's a little bit of an entitlement mentality sometimes to think that we're actually going to get much of an inheritance. And certainly not to start thinking about what you're going to get early and start pre-spending it in your mind. I think that that's part of the problem for the children's generation, that happens. And so you need to consciously curb some of that issue that's going on in the background. So yeah, set expectations, talk about it with each other, plan early enough. Don't try and do this, you know, 6 months into a cancer diagnosis, when there's no room to fix things up, and no room to have the deep conversations either. It can add extra stress to that element. What I also wanted to discuss was vulnerable beneficiaries. And I'm going to discuss some elements of different trusts that you can use for vulnerable beneficiaries. And you may also be able to access this sort of a trust when you're thinking about providing for your spouse as well, or maybe even for children. So let's just focus on a disabled child who is never going to be fully independent. So there are 4 different kinds of trusts that I want to talk about. The first one is a life interest trust. Now, this is the one that Jay set up for Gloria. So this can be used for a spouse. It was managed by someone else. So the executor is in control, but the funds are set aside for the person for life. So it can provide a house, it can provide a nest egg that earns income. So nothing actually ends up in the name of the vulnerable beneficiary at all, but you know that they're provided for. So that is one way that you could provide for a vulnerable beneficiary. Another way is a more flexible style trust. So with a life interest, we have said that they're only able to access income. So they can't access the capital is protected. A more flexible kind of discretionary trust could be used. Now, again, you wouldn't have the vulnerable beneficiary being in control. You'd have someone else as the trustee of the trust, but there'd be more flexibility about what the funds could be dipped in for. So it wouldn't just be income. It could also be capital. The trust could also buy a different property for something more suitable for a disabled person to live in. So that could be a way to go. So we had a life interest, We had a flexible family trust. The third option is an inflexible trust called a protective trust. In a way, it's very similar to a life interest. Doesn't necessarily run for life though. But again, in this case, it is capital set aside where income only is paid. So it's like paying a pension or an annuity essentially. And that vulnerable beneficiary never gets actual access to the capital. So that usually wouldn't include a house. It might just be, you know, 200,000 put aside for someone in a protective trust. So they've got something, but they don't have access to it. So a protective trust might be better for someone who has a gambling problem or a drug problem rather than a disabled person, because it's there, they're getting a little bit of pocket money, but it's not enough for them to kill themselves. But the fourth kind of trust is the most interesting kind of trust, particularly for a disabled child, and it is called a special disability trust. Those other three trusts I spoke about are assessed as income and as assets for the sake of Centrelink. So you might knock your adult child off a pension if that's their only income. Whereas a special disability trust is a trust that is approved by Centrelink, and you can have up to $600,000 in there that is not assessed by Centrelink. So that's a really interesting structure that you could consider. Now, the first three need to be set up in a will. The special disability trust can be set up in a will, but it could also be set up while you're alive. So it has a little bit more flexibility as well. If you set it up while you're alive, it is then something you can put funds into in your will. So it works both ways. So there's some options around trusts, particularly for vulnerable beneficiaries, but it sort of works as well for spouses of a second marriage. So we're getting towards the end, we're at the half-hour mark. So I am again going to explain what's part of the estate planning process. So this little poker chip image has all the elements in it that I do as part of the family legacy plan at TBA Law. So we look at property ownership. So this is what I was talking about earlier with how you own your assets in terms of whether it's jointly with your spouse, whether some is joint, whether some's individually owned. It's important to know so that you know what is an estate asset and what is not covered by the will. The will is obviously an important component. Enduring powers of attorney. Now, the powers of attorney activate while you're alive, whereas the wills don't come into play until you pass away. So the power of attorney is there if something happens to you in terms of like a brain injury or an accident, or even if, you know, you were on a ventilator for a couple of months recovering. Appointment of medical treatment decision makers. As I said, important for blended families to make it clear to the family who has the decision-making power. Advanced healthcare directives. So the decision maker needs to know what decisions you want made. So that's the document where those sit. Superannuation. You need a binding nomination on your super. Otherwise, the super fund decides what to do with your super. So your binding nomination is like a will for your super. Testamentary trusts. So I covered off those 4 different testamentary trusts when we were talking about vulnerable beneficiaries. There are also minors trusts. So we talked about that when Jay was setting funds aside for Manny and Joe until they were 25. That would be in a minors trust. So those are 5 basic testamentary trusts. So there are more, but those are your basic categories. Life insurance, I don't so much look at TPD insurance, but life insurance, if there's significant debt, we look at, you know, have you thought about making sure that you leave your spouse in a good position? But we also look at, well, who gets the life insurance? Who is it paid to? And again, life insurance might be a good tool to have an extra policy to pay to the kids, so everything else goes to the spouse. Instructions to guardians. If you've got minor children and you have to appoint guardians, instructions to guardians are often important as well. So while I'm on the point of guardians, if you've got a blended family and your children are under 18, it's still worthwhile having guardians in your will, because a lot of parents think, well, why should I? The other parent will automatically be the guardian, won't they? Well, no, you have parental responsibilities yourself. You can pass your parental responsibility and role onto someone else. The other parent still has theirs, but why shouldn't they see their step parent? Why shouldn't your spouse have the guardianship role? Family trust appointments. So for those people who have family trusts, run a business through a family trust, or own second properties through a family trust, or things like that, just like we were talking about with Jay's business, the control of a family trust or a business can be either put through a will or not. So if someone in a blended family had a lot of investments in the family trust, they might leave the principal place of residence to the spouse, and the whole family trust goes to the kids. And they can do that outside the will, so the spouse can't dispute that. Personal effects. I don't like a lot of personal effects sitting, or gifts of personal effects sitting in a will. I think it should be in a separate document, so we go through that. And then in memorial instructions, same thing. They shouldn't necessarily be in a will. If someone passes away, people often don't look at the will straight away. Memorial instructions, if they're important to you, should be separate. So these are all the elements of the family legacy plan that I do. So things aren't, doing a simple will anymore these days. This is what you get. This is the standard. And how do I do that? 2 appointments over 2 weeks, all done. So if you wanted to do this, I'd send you out some initial information via email. We have our first appointment. This is our information collecting brainstorming session. I guide you through this. I know what to ask. I'm thinking about all the stuff. I'm not going to overwhelm you with it. We're going to get to the point where you've made decisions. If there is any decisions you haven't made, that's fine. You've got 2 weeks to think about it. And we finalize things via email over drafts that I send to you via email, and we go backwards and forwards a couple of times to get those right. Second appointment, we sign, everything's valid, done. It's all on Zoom at the moment. Then if you have powers of attorney to do as well, the attorneys you appoint have to sign acceptances. So we run around, do some of that, and then we deliver the final documents to you as certified copies. So that's how it happens. I'm sure you've got questions, so I am coming to those. But one of the questions people often ask is cost. Well, what does it cost? People in Melbourne doing a similar thing, you're going to pay $3,000. For a couple, you pay $1,100, right? Family legacy plan, it's not each, that's it. That's the fee. For an individual person, $800. For a couple, you get the discount because it's a similar amount of time for a couple as an individual person. Double the amount of documents, but similar amount of time spent with you. So there we are. We made it a little bit over the half hour. Thank you very much for hanging in there with me. My email address is on there. That's my direct email. You're quite welcome to use it. Email me any questions you have within reason, or email me about making an appointment. I'm now going to go to the questions. There's a Q&A box, or there's the chat box. So let's have a look. Hopefully I haven't been speaking too fast for you. I tend to get on a roll. No, I don't much like the Q&A box, but let's have a look in the chat box. All very quiet, guys. If you're struggling to find the chat, it's usually along the bottom. It says chat. Otherwise, hang on after the recording. And for those watching the replay, again, the button on the the landing page for the webinar has a Q&A thing which emails to me. So by all means, please do that. Otherwise, I hope that was useful. Like I said, I do talk quick, and that's why you get a replay.